Let me thank you. I'm Paul Hedges with the San Diego County Medical Society. You're registered to attend. Are you ready for the new 2024 laws webinar? Put together with the Doctors Company and Keith Carlson, who will get introduced here in a second. At the end of this program, participants will be able to develop increased awareness of 2024 laws and the potential sanctions against medical providers who violate them, understand new employment laws that may impact your medical practice, and education staff and colleagues regarding current federal and California telehealth requirements. If you have any questions, please throw them in the chat on the webinar, or send them to SDCMS at sdcms.org. And with that, we will get started. Kathleen, if you want to put up the slides.
Keith Carlson, I'm happy to have you with us tonight. Keith is one of the founding members of Carlson and Jaya Kumar. We partner with them throughout the year on programs. The law firm practices all aspects of employment law, healthcare law, and litigation, business law. And it's who the Doctors Company, we refer our doctors and callers who need something that's not related to their malpractice issues to the great practice of Carlson and Jaya Kumar. So thank you, Keith, for being here tonight. Ignorance of the law is no excuse. This was a comment by Thomas Jefferson. And that's where we wanted to start tonight, that if you don't meet the requirements of a law, you will never be able to defend it saying, well, I didn't know. I had a doctor call me the other day and I said, well, did you check cures? And he said, what's that? And I explained what the cures database was and how the medical board is after the doctors because they're auditing that. And he's been a doctor for 27 years and he'd never heard of cures. Now, he's a great doctor, but he just hadn't been exposed to the information. And so he did. He got audited by the medical board. And I said, well, we'll assign an attorney, but you can't say, well, I didn't know, but now I know and I'll do it. So why are we talking about this? On the next slide, just very quickly, I want to mention that you have extraordinary pressures on you for compliance, taking care of people. You have people's lives in your hands. And at the same time, you are exerted into a pressure cooker when you have to face all of the laws, compliance issues for healthcare, for your license. And you have to live with the Business and Professions Code in California, which governs your practice and your license. And failure to comply with laws is a violation of the California Business and Professions Code. And again, saying I didn't know the law is not a defense. So compliance is your only option. I'm going to turn it over to Rich to talk to us for a moment about meeting those requirements and about some of the most common ethical concerns and violations you face. Rich?
Thank you, Kathleen. Good evening, everyone. My name is Richard Cahill, and I'm Vice President of the Law Department for the Doctors Company.
There?
Yes, can you not hear me?
I can hear you, Rich.
Okay, I'll go ahead then.
We can now.
So as Kathleen mentioned, this is a critical topic. When I first started doing healthcare litigation defense 40 years ago, the crucial issue confronting most practitioners was whether or not you were going to have an issue with professional liability. But I think over the course of the last 10 or 15 years with lots of federal and state legislation, the critical issue is now compliance. And you're governed by, as Kathleen said, Business and Professions Code, the Medical Practice Act of California, which starts at Section 800. And failure to comply may lead to a medical board complaint and an action, which may start with an investigation. It may involve an adversarial administrative hearing before an administrative law judge. Adverse findings of fact and conclusions of law could be entered, and a variety of very significant penalties which you need to be aware of, including public or private reprimands, fines, probation, monitoring by a proctor, which is then charged back to you as the practitioner, suspension or revocation. Those can have significant other consequences, including reporting to the National Practitioner Data Bank. And then every 2 years, when you have to do your recredentialing at your facility, those will be evaluated and determined whether or not they're significant. I think the next thing that we need to discuss are some of the most common ethical violations. of what I've seen over the course of 40 years, the allegations of ethical issues involve fraudulent and deceptive practices, include fraudulent advertising, misrepresentation of credentials, and related issues. Also, unprofessional conduct, which may include upcoding in your billing practices, ordering unnecessary tests, and exceeding your scope of practice. A major issue that we'll talk about later is whether or not you, as the practice lead, have any type of responsibility if one of your subordinates exceeds his or her scope of practice, and of course you do, and there may be vicarious liability for that. Also, whether or not you as a practitioner are unfit to practice, either because of a physical or a mental impairment. Also, very critical, throughout this whole program tonight, we're going to stress that you need to make sure that your patient records are properly kept, maintained, and accessible in the event that a patient needs them, or another organization such as the California Medical Board wants those. If there's any violation of federal or state laws, such as HIPAA, the Americans with Disability Act, the California Confidentiality of Medical Information Act, those are critical, and you must be sure at all times that you're in compliance. And those of you who are members of the doctor's company, please feel free to call your risk manager if you have any issues. And failure to self-report. Again, I encourage you to Google California Business and Professions Code 800-SEC to see what your responsibilities and requirements are. Our next slide deals with employer liability for harassment. Employer is automatically responsible for harassment by a supervisor within the practice that results in some type of negative employment action, which may result in termination of an employee, failure to promote or hire, and loss of wages. The employer will be liable for the harassment by a non-supervisory employee over whom he or she has control, such as independent contractors. So if somebody comes onto your practice, they may not be an employee, they may be an independent contractor or a vendor. You may still be responsible for anything that they do in violation of federal or state law. Keith, if I could, I'd like to turn the program over to you at this point.
Thank you, Rich. Appreciate that. And touching on a little bit of where we're going to be going in our next slide over the course of the presentation, we're going to start in the area of the new healthcare specific laws. But as Rich was just mentioning, there are employment considerations also if you have your own practice. Almost all providers are both healthcare providers and employers in California. So we've broken down the presentation essentially into two halves that my firm's practice area focus on, which are healthcare laws and employment laws. So the new healthcare laws are really all over the place. There's a lot of different issues you can see that we're going to touch on here. We'll have to do them relatively briefly just to give you a sense of what the new areas of the law are or where there have been changes in existing areas of the law. If you want a deeper dive on any of those, of course, we can do follow-up on it, but given the time constraints tonight and how many new laws there are, we will be moving somewhat quickly and not be doing as deep of a dive here. Some of them very likely won't apply at all to your practice, and some might be spot on. As Rich pointed out, you need to be aware of them one way or the other because they can affect malpractice claims, certainly, but also the licensing board complaints or investigations against you. Sometimes this can impact what and how you can bill. And then the other reality is, in some of our cases here tonight, it might actually help you expand and grow your practice with the way they've modified some of the laws. So what you're first looking at here are all the different areas we're going to touch on. And like I said, it's really all over the map in terms of types of subjects we'll be covering. So I want to go to what was recently enacted, AB 1369, David Hall Act. And what this one is an expansion of out-of-state providers' ability to provide telehealth. You've known telehealth's been coming for, or been discussed and moving forward, advancing in your ability to use it for a better part of a decade, if not a little bit more. Then with the pandemic, it really shot up, and a lot of the regulations relaxed and made it more and more feasible to take advantage of telehealth with patients. This one is taking yet another step where an out-of-state provider can provide services in state if certain criteria are met. Namely, the patient has a life-threatening condition. How is that defined? It means there's a high likelihood of death within months, not years. There's the informed consent and a release of records to the primary care physician, and the patient can't be in a clinical trial for the condition being treated. The out-of-state provider has requirements in good standing, no prior discipline, and also be an expert in the patient in California's particular condition. So that's what we've got in effect now in California on the expansion of telehealth. Next up, some changes to hospital operations that may or may not affect you, but I think some of these that don't necessarily affect you directly are useful to look at because they could be coming to a practice, or particularly larger practices near you. There is an expansion under AB 1392 in how hospitals operate on procurement, and their requirements to promote and report on their efforts to get essentially minority-owned businesses involved more heavily in the hospital's procurement efforts. There will be a plan required beginning next year in the middle of the year that the hospitals are going to need to provide to show what their plan is. Interestingly, in light of recent United States Supreme Court case, they've phrased this as you need to show in your plan your goals, but not quotas and steps you're taking, that is, as hospitals are taking to make hiring easier for certain groups of business owners. Smaller hospitals aren't under as strict of a requirement, but they are encouraged to do the same plan making. The state has added kind of a paid commissioner position of someone who is an expert in the field of supplier diversity. That's the phrase that they use. And the state will also, through the Department of Healthcare Access and Information, going to be providing guidelines, which are voluntary use to review the plans to make sure they are complete. But as often the case in the law, when the government issues voluntary plans, they really become important guidelines. Next up, mainly in hospitals, but in other healthcare facilities, SB 302 affecting cannabis has essentially expanded Ryan's law with respect to terminally ill patients. And what this does is it allows, in certain situations, in many healthcare facilities, it is not smaller doctors' offices, in case that's anybody's question, but it is going to allow for cannabis use. There is an interesting carve out on this, in that facilities don't have to comply with this new law if the US DOJ or the Center for Medicare and Medicaid Services is inquiring about the facility and the use of cannabis at the facility. So certain facilities and outpatient setting can be required or will be required under this law to allow patient use of cannabis. Unless the feds are asking about it, then they won't. So cannabis expansion 302. Next up, again, might not, unless you're in an emergency realm, affect you directly, but an interesting thing, I think, with regard to quantifying efficiency in practices and in different areas. So I think the spirit of AB 40 with respect to emergency medical services is interesting, which is really designed on looking at the efficiency of the transfer of patients into an emergency department. But at the same time, you can imagine that the idea behind this of monitoring numbers by the government could be growing into all sorts of different areas down the road. I haven't seen anything yet. We've already begun the process of looking at the bills that are in the works in this particular cycle. But at the same time, what they've done here is have a state authority have an e-signature program so they can track the time the ambulance arrive and then when care is transferred over into the hospital and the physician receiving the patient. And then the agencies are going to have to develop a standard transfer time and show that they're meeting that, 90% of the time. They also are going to require the ED staff and employee representatives, i.e. union reps, to create protocols for this offload time. They're trying to reduce offload time in hospitals. And then the California EMS Authority is going to monitor every hospital's monthly offload time data. So there is a whole new layer of looking at how efficiently hospitals are receiving and ambulance to hospital transfer of patients is happening. So kind of even if you're not in an ED, I think it's interesting the scope of the monitoring that is going on here. And being off your times can be a reportable issue. Let's turn next to AB 1029, which deals with advanced healthcare directives. So there's always been the ability for representatives of a patient to consent to certain things. And those are listed statutorily typically. But what we now have is that the representative cannot decide for the patient as to certain listed procedures. And you can see them there in the third bullet point, convulsive treatment, psychosurgery, sterilization, or abortion. You'll see still in the other side here of the Dobbs decision, California legislature has a lot of abortion-related laws being worked on or having passed. This is one, you can see it in there with respect to changes to advanced healthcare directives. And there is a separate directive for psychiatric issues. So a list of things that representatives cannot consent to is what this one has to do with. All right, next up, and this is one where I mentioned there might be some in here that have an ability to not just be more monitored and restricted and have more reporting duties, but actually maybe you can increase what you're doing with your practice for those of you that are interested. AB 834 is multidisciplinary, and it has to do with partnerships. There's a long time under the Professional Corporations Act where you could have multidisciplinary practices that involve podiatrists as well as physicians and surgeons. Now that's been expanded to professional partnerships. Previously, you couldn't have had that. You would have had to all be one license type. This expands that. I don't know the history of this one, and it is kind of interesting because typically from a corporate practice standpoint, it is safer for all of the principals to be incorporated rather than a partnership, but maybe there's some reason that your CPA thinks you'd be better off in a partnership rather than in a professional corporation. If so, and your practice meshes with podiatry in any sort of way, just be aware that they have expanded multidisciplinary professional partnerships to now include podiatrists with physicians and surgeons. Again, might not be spot on with what you're doing out there, but there are a lot of different type of multidisciplinary options. And if this trend were to continue, it would just open that up more so that it wouldn't all have to be only in a professional corporation as it is now, but it could also be in partnership sort of setting. Just by one note there, when you're dealing with multi-specialties, nothing changes with anybody's scope. So if you have a partner who doesn't have the scope that you do, but they say, well, we're partners, I get a vote. No, they don't. They can vote on business activities, but not on professional activities that require a license if the issue is beyond their scope. All right, moving on, more with respect to practice expansion. This one specifically as to dental students, and a pilot program for dentists from Mexico. Again, we'll see how this expansion affects practitioners in different disciplines, not just dental students, but we're already seeing some action with respect to medical students. We'll get to a law later that is going to have an impact on residents from out of state. But what might this sort of thing that we're seeing in AB 936 do with respect to medical students, or maybe licensees from other countries? We saw from telehealth, we're allowing out-of-state practitioners. Maybe the trend is going to be towards allowance of out-of-country practitioners as well. What it does in this specific one, however, is it's going to expand the ability for students, dental students that have already begun their clinical training, to be working under supervision at a higher level than they would have been previously. It also is requiring the medical board to issue a 3-year license to certain applicants from Mexico to do this pilot program where they can practice under a special kind of a provisional license in California. Background on some of these things has to do with areas of need where you have certain areas in California with insufficient coverage, according to the legislature, with practitioners. And so they're looking to expand the number of people that can provide care. All right, so those were a couple areas where we see practice expansion. Moving to the next one, it's related, but this one has to do with ACGME, as I'm sure most of you are aware. That's the National Accreditation Group for Graduate Medical Education. And essentially here, physicians who are not licensed in California, but are in ACGME approved programs, are going to have the ability to practice quicker. Sometimes there's a lot of paperwork snafus that impact a licensed physician from another state coming to an ACGME approved residency program as a trainee, but they don't have their license, so that impacts the clinical work and things get delayed. So this is trying to smooth a bit of that over. But there again, you see someone who is essentially, there are rules of the game being enacted in Sacramento that allow a non-licensed California physician who's licensed somewhere else to be able to practice in California. So it's an interesting trend in these last few laws that we've been talking about. Moving forward, and we're going to cover this later in the program, but the CME, your continuing medical education requirements, have been modified once again, and we already had certain cultural and linguistic competency requirements for CME. I believe Kathleen will be touching on those towards the end of our time, but this impacts, essentially heightens those, and it requires updates on what are known as threshold language requirements for these classes, and the threshold language requirements are designated with respect to language groups in certain communities that are served. All right, so CME has changed once again in the cultural and linguistic competency area. As I mentioned, we've got some issues that are going to be impacting the board and the oversight of physicians. Here, this one is actually a requirement on the board, not on the physicians, which is interesting. Seems like it usually goes the other way. But now licensing boards, if they get a notice from a licensee, have to update the license itself as well as the public description of it to reflect a new name or gender. And for the online license verification sites, the boards are going to have to go about removing the former name or gender from any public information on the internet. They can't publish the former name or gender online. They have to post a statement telling the public to contact the board for more information. And for certain licensees, they can note that the licensee was previously subject to an enforcement action and direct the public to contact the board. Because you can imagine if someone was disciplined under a former name and then they're practicing under a new name, same person, the patient or member of the public goes and looks up the new name because they're about to go see another doctor, and then they wouldn't see necessarily if they looked up that name, what's going on license wise and prior disciplines. So some name change and gender change related changes to how the boards are going to be issuing and publishing license information. All right, moving on, a couple areas that we'll touch on now: privacy and consent, specifically in this area of sensitive services, which has been a big theme in the last couple of legislative sessions, as I mentioned, and then also a couple items on drug treatment. So let's turn first to AB 352, and this is disclosure of medical records. So by the middle of this year, anyone who's maintaining records for providers or facilities is going to have enhanced security features and segregate records dealing with abortion, contraception, and transgender matters. I mean, that's essentially when we talk about sensitive services, that those are going to be in that category almost every time, and you will be seeing more bills and already enacted laws that are dealing with those issues. Disclosure of anything abortion related. Now there's even more prohibitions on that than there were before, including disclosing information to other states' agencies, and where it can be avoided, to federal agencies. So you won't have liability if you make such disclosures, as long as it's already legal. Under this new law until 2026, if the provider is trying, quote, in good faith, close quote, to avoid disclosing the information. So essentially what California is looking here is, we don't want our providers providing abortion, contraception, or transgender information that would otherwise be legal to provide to another state. And also that applies to various data exchanges that you would normally be required to provide it. Certain abortion related information is now excluded from being required. Basically enhanced privacy on sensitive services, enhanced security on keeping records about those services. And we've already seen in the last 2 years, and we'll touch on a couple more as we go here, the fact that they don't want California providers giving states that have different abortion access rules information, or disciplining a doctor from another state who's also licensed in California. All right, so moving to the next up, minors consent without parental consent has been expanded under AB 816, having to do with an opioid treatment drug. I'm not even going to try to pronounce it. I'll probably mess that up, but buprenorphine, I think. The old rule was 12 and older could be treated for alcohol and drug problems without parental consent, but not with respect to narcotic replacement treatment. This is going to expand the minor's ability to consent to the synthetic opioid to 16-year-olds if they are in physician's office or healthcare facility. And then there's other replacement treatments allowed by federal laws if they're in a program that the minors can now consent to without parental consent. All right, next up, I believe, is AB 1731, related to the same drug for treatment in an emergency department. This law now provides a cures exemption with respect to consulting the cures database, which Kathleen had mentioned earlier. Here's an exemption if furnishing the drug happens in the ED. They don't have to consult on the cures database for that one. All right, good. Next, more on sensitive services. AB 1707. This is protecting its license protection if an out-of-state physician who is, let's say, also licensed in California, have 2 licenses, and you provide a sensitive service. And we've kind of talked about what some of these are, but the broader definition involves mental or behavioral health, sexual and reproductive health, sexually transmitted infections, substance use disorder, gender affirming care, and intimate partner violence. If those are provided out of state and caused a violation in the other state, but they were legal in California, this is telling the Department of Consumer Affairs, which is the overarching group for the licensing board, not to go after the doctor in California. A lot of times, if you get disciplined in North Dakota and you have a California license, the California Medical Board is going to come after you for what happened in North Dakota. This is saying don't do that in these cases. So they can't act against your license here. And similarly, for those on a medical staff, the medical staff can't deny or suspend privileges for the same reason. So this is an expansion of the protections for providers giving those services. Okay, next, Senate Bill 345. Again, dealing with out-of-state sensitive services. And this one has to do with California's confidentiality rules and the collection of the data and not allowing that to be disclosed. So it has, I mean, it has a number of services, but again, confidentiality is increasing. The unemancipated minors, parental consent issues with respect to abortion is changing. It's amending the penal code. This one was touched on a whole bunch of different statutes, but essentially provided more protection in the realm of sensitive services for the providers who are offering them against discipline and frankly lawsuits. So a related statute was SB 385, the next one, and that is expanding physician assistants' abilities to perform abortion using certain techniques. It does create training requirements that allows the PAs to perform them outside the presence of a supervising physician and protects the licensee from any license discipline, as well as civil liability in certain situations. So further expansion. AB 1070 is next up, and that's also affecting and expanding PA's scope of practice. It also affects physicians' ability to supervise. In most situations, that's going to jump from supervising of 4 up to allowed 8, and expands what they can be doing as well. Turning to Senate Bill 667, this another extender expansion. This was an expansion for nurse midwife scope of practice, but again, it's going to require supervision by a physician or servant. It includes admission, discharge from hospitals, providing prescription drug, lab testing abilities, and certification for unemployment, all related to pregnancy. So quite a few things impacted there. Does still require physician or surgeon supervision. Okay, so now we have kind of hit a good pivot point, and we're going to shift into some of the areas that are going to affect you all as employers. Paid sick leave has changed. There's enhanced discouragement to have non-compete agreements with your employees, and also some changes to workplace violence. First up is SB 616, and this one has to do with an already existing rule regarding making sure you have paid sick leave, and that was an hour for every 30 worked. But now you are going to have to provide 40 hours of paid sick leave by the 200th calendar day. So basically, you used to have to do about 24 hours of paid sick leave by 120th day. That still applies, but you have to kind of keep having it tick up until it hits 40. There can be an accrual cap on the paid sick leave at 80 hours, whereas before it was 48. However, the one thing that does help the employers, I guess, a little bit here is they can limit the use of that to 40 hours or 5 days. So that there's a cap that's not all the way up to the 80. And then there's some allowances. Employers, if you want, you could front load the sick leave, give it to them all at once. The thing is, if you do that and then they leave before they hit the mark, then you've kind of given them, they use the leave and then terminate their employment. You could end up having given more than you needed to, but you don't have to track further accrual. All right. So this paid sick leave, the sick leave law has been around. It's just increased the numbers that have to be provided. Turning next to SB 699. This is with respect to non-competes. Non-competes have been disfavored in California forever. It's essentially a contract that says if you work for me and then you leave, you can't work in, let's say, healthcare or a doctor's office or be a physician anywhere in the state of California, anywhere within 25 miles for the next 5 years or whatever it might be. Those are a restraint on trade, and California has a statute that has always been against them. There have been certain there's certain exceptions to them. They're pretty few and far between. This one makes it even more disfavored. A contract restraining a person from practicing or being a tech or an aide or whatever in your office is going to be void. And the interesting component to that, the non-compete applies to contracts where the person being restrained is not a party to the contract. So let's say you have a subgroup, you've got a group and they all work with one of the doctors. The doctor has a non-compete, but the whole group goes across the street to start a practice. The whole thing is void, and there's no action against any of them who left. Now, they can't steal your stuff, but that goes to making sure your confidential information is protected and you're taking care of your proprietary information, financial information, patient lists, and all that sort of thing. Any contract that's void under the non-compete law is unenforceable, regardless of where it was signed. So basically, if you had a multi-state deal, it wasn't going to matter that it was legal in Nevada. It's not going to be legal in California, even if they signed it in Nevada. All right. AB 1076 is next. More on non-compete. They were really on the chopping block in this last cycle. Can't have them in employment contracts. So in the one we talked about them being void, they used to be void. Now the clauses are not just void, but they're illegal, and then that could cause employer liability for just having them in there. Because one of the old tricks was, well, let's just put it in there and let's see if they're actually going to get a lawyer and sue me and try to fight it. They'll think they can't. Well, even if you put it in there, now they can actually turn around and sue you for it being in there. Whereas a lot of people used to just kind of put it in there and hope nobody would look. If you have contracts that have them in there right now for employees hired after January 1st, 2022, they need to be notified, and they had to be notified this year. You still want to do it, and they have to have an individualized communication. So make sure your employment contracts do not include this. If they do, you're going to have to look into doing a notification, or the employer will face civil liability on having them and not notifying people that they are not viable. Okay, SB 553. This is having to do with workplace violence prevention. You got to create a plan. You have to train the employees, and there's a lot of maintenance of records regarding workplace violence. These have to be in effect by the middle of this year, and they have to be accessible to employees. This covers just about every employer. So it's going to be small practices, large practices, hospitals, the whole thing. And there is a specific definition on workplace violence in this new statute, but it's fairly broad. And you're going to have to maintain and update plans to make sure you have a prevention plan that employees are aware of and trained on. There's a couple of different issues going on around here with the prevention plan. So let's go on to the next section of it. Your procedures are going to have to handle reporting of violence in the workplace and make sure there is a prohibition on retaliation for any report. They have to make sure that employees are complying with the plan. You have to have procedures to communicate with employees regarding violence issues. So it's a whole list of different things, and what to do if a workplace violence emergency is happening, and make sure we got training for dealing with workplace emergencies. It's a pretty exhaustive, comprehensive list of things that have to be done. Let's take a look at the next slide as well. Yeah, and so see, there's a lot of different things you're going to be developing procedures on, and making sure that they're communicate and that there's been training done on it. And then you'll note at the bottom there, that you're going to have a process of reviewing the effectiveness of the plan and revising it as needed. So you can't just implement one by July 1st and have it sit there for 20 years and never get touched again. It should be a living document. Next up, here's a log that you're going to have for violence incidents, and every incident has to be logged here. Again, obviously the good goal here is to have a plan for dealing with these situations and employees knowing it, and increasing the safety in the workplace. The downside for the employer, of course, is if you don't comply with all these different things, you open yourself up to lawsuits, as well as not dissuading the violence. And then last up, there's got to be training done when the plan is first established, and there's a lot of requirements for what that training has to look like. And then finally, on this SB 553, there's a lot on records that have to be kept and maintained and how they're done, and the departments that are going to be looking at them. Last little note there at the bottom, this new law, which obviously is huge and it covers a lot of different things, it allows employers, not just the employee who's being necessarily harassed or threatened, but employers can now petition for temporary restraining orders on behalf of their employees, if the employee, for some reason doesn't, but the employer feels like there's a reason to go in and try to get a restraining order. The employer now has standing to do that, which is an interesting shift. Okay, keeping going into some other areas of employment laws, there's a very noteworthy healthcare minimum wage hike, and then we've got some more traditional employment related issues that are happening. So as you probably heard, next up, SB 525 increased the minimum wage for healthcare workers to $25 an hour, and then some incremental wages that are going to happen kind of annually thereafter. Depending on which group you fit in, it's going to be happening over the next 2 to 9 years. These are typically for larger systems or groups that are part of those systems, and then or you have 25 or more than 25 physician practice groups and clinics that are going to be under that, as well as certain other healthcare employers. So minimum wage, yes.
I'm going to jump in just because we got a question on that. I think it'd be pretty easy to answer.
Sure.
Does the minimum wage for healthcare workers apply to private practice with 15 practitioners and 80 employees?
I think the 25 plus is dealing specifically with 25 physician in the group. So
that is my understanding as well. So
yeah.
They are clear. That does not affect your practice yet.
Yeah. Okay. Good. Next, AB 594. So this one is interesting. It's moved one of the hot areas in our employment practice, which is wage and hour, meal break, or whistleblower issues. We get lawsuits like that all the time. And frankly, medical practices are ripe with these because meal breaks and rest breaks are so hard to do because of busy schedules and patient flows and all that stuff. You have to be really diligent. But what it's now done is essentially allowed prosecutors to independently come in with civil or criminal actions on certain violations of the labor code. And it's like we already had a lot of plaintiffs' attorneys, and now it's opening up. Essentially, I think they're thinking the labor commissioner doesn't have enough resources, so they're going to allow prosecutors to jump in on the action too. The only limitation is it has to be in their jurisdiction, so county or city, depending on what you have there. Okay, keeping moving, we're running low on time. Is SB 428. And as I mentioned, there's this new ability for employers to seek TROs in the violence situation. Here you also have a harassment situation. The employer doesn't have to wait for a credible threat of violence. They can go in earlier. So increased ability to get a restraining order, and the employer can be involved with that. And so just realize there's some new rules that are beneficial to employers, not just employees, but employers who want to get restraining orders. Okay, last few slides. Don't retaliate. Never retaliate anyhow, but this adds a lot of employee protections, including a rebuttable presumption that if they got a negative job action against them within 90 days of making a complaint, it's presumed that the negative action was because of the complaint. And if they can show an unlawful retaliation against a whistleblower, there's a guaranteed civil penalty on top of any other damages they might have. Okay, next up is SB 700. And this has to do with seeking information from applicants or prohibiting them from getting a position based on prior cannabis use, with some exceptions. So be very wary on information relating to cannabis in the employment context. You want to probably seek counsel before you go down that road with current employees or applicants. And then last but not least, I believe, yes, is a new form of job leave, reproductive loss leave. This will affect employers with 5 or more employees. Now, Paul, to your earlier question, 5 or more employees is the traditional employment standard for when laws kick in. It can be 5, 15, or 50 usually. That would include staff. That would not just be the doctor members of the practice. This would be employees, even if they're part-time receptionists. They're going to count to it. Basically, if there is a reproductive loss event, they're going to be able to get leave, and it can be capped at 20 days within a 12-month period. It can also be an event that is related with respect to a family member. So, and the loss events are defined. So it's a lot of information. I need to turn it back over to Kathleen to get you some more. And we aren't able to do a deep dive on all of those because there's just so many laws and some of them are rather complex, but certainly available after the program to help you out if you have further questions. Kathleen, back to you.
All right. And yes, both the slides and those instructions were sent out this morning. Those who didn't receive them, please email sdcms@sdcms.org, and we'll get them forwarded to you. First question, Keith, and the timing of this is weird. I'm not sure which bill it is. Is this referring to treatment for intimate partner violence?
I don't know what slide that is. I think if it was the ones in the employment context, no. We'd have to pull the slides back up. Well,
I'll try to sort through it and look at the other one.
There's a couple. There's sensitive services, which the answer would be yes. That is what it's referring to on sensitive.
That's what services. It was. It was earlier. It was 6:30.
Okay.
They asked. So
okay. Yeah. So that that can be protecting information on sensitive services. That would be on the employment ones of providing the leave and TROs. Not necessarily. It could be any form of violence.
Yeah. No. It was earlier. Non-compete apply to interstate telehealth companies.
Yes, it will, as it affects a California worker. And this is the thing. Just real quick, war story. But
Perfect.
I got an employee. I was reviewing a contract for someone who's going to work for this company that was based out of New York, and then the New York side said, "Well, we got a high-priced New York lawyer who says this non-compete works in California." And I said, "Well, I'm a low-priced California lawyer who says it's never going to work." And so California is not going to put up with a non-compete, even if they wrote it in New York. They don't care. Okay.
Violence prevention. Where does one get violence on 553 plans? I know I have an outside HR company. We do a workplace violence training through them, and they, make sure that we have an up-to-date plan with all of our employment plans.
Yeah. One answer. And then, our firm is another one. So
Perfect answer. Yeah, exactly. It's like you can put together trainings on that. You can put together the plans.
Yeah. Looks like Susan there has the same thing on 553. I'm not sure what the question is. Yeah.
What would be?
Yeah, it would be just whatever the latest state posted minimum wage is. And then my only caveat on that, I've given up trying to memorize them, even though I do employment work, because local jurisdictions are now coming up with their own minimum wages. So it's whatever the highest minimum wage ordinance that you're under. So it's probably state of California, but it could be
City of San Diego is a higher one. So you're
there.
right.
You go. So that's an example.
We increase every year, and my staff is above that.
So you have to know your local jurisdiction minimum wage as well as the state minimum wage, and you have to apply the higher of the two if you're not under the healthcare minimum wage. Break issues, and does that only apply to non-physicians or physicians as well? It certainly applies to most non-physicians. There could be some non-physicians that it doesn't apply to, which is an exempt worker. That would be a fairly high level type manager, supervisor. You'd have to get into what the exemption rules are, but there could be people in a practice that are not physicians. Also, there could be physicians that are non-exempt because of the requirements for the professional exemption. If they don't meet, let's say, a certain salary threshold, then even though they are licensed, and normally you think of them as salaried and exempt from the meal and rest breaks, they might not be. And where you'll often see that is on part-time people who just aren't working enough to make the threshold amount, which is typically 2x minimum wage annually. All right.
If I could make a comment to the group, I get a lot of calls about, does the doctor's company provide this workplace violence prevention and all the manuals and documents you need? And we do not. That is not covered under our malpractice policy. So you're going to want to look to, if you're not with the doctor's company, you can check with your organization or your malpractice carrier and ask them. And as you heard, I think there are some resources in San Diego. We refer to Carlson and Jaya Kumar if somebody needs something, because we feel very confident in the work that they're doing in this area. And so just so that you know, the malpractice carriers, as far as I know, do not provide that training and information. It falls under the labor and employment issues.
Yeah, and we're happy to help there should anybody need that. And then the another one on SB 525, it looks like here from Anonymous. There is, so we'd have to get into the specifics of it because there's a breakdown in the bill about how it applies to different levels of entities and frankly, how much. So there's a catch-all, all other healthcare employers would increase their minimum wage to 21 per hour in 2024 and to 25 by 2028. But healthcare employers is a defined term, so it's going to depend on this independent physician practice and if it's going to fit or not. Typically, let's just say it's a regular group under 25, that's not going to fit the definition of a healthcare employer because it's defined in the statute as more than 25.
Yeah, and that was an intentional addition to the statute to protect those independent practices with under 25 physicians.
Yeah.
So the other, even if you have PAs or NPs or partners, they do not qualify under that.
Right. That one, well, there was a lot of wrangling. And another little add to the statute is it applies to the dialysis center because you've noticed they've been facing initiatives over the last few election cycles. And so they got wrapped into this. So there's a lot of kind of horse trading up in Sacramento over that one. I would anticipate it'll cool down briefly, but I also think it is a sign of the times that you'll see more legislation like that. And that's part of the reason why I wanted to go into some of the areas tonight that maybe aren't going to be spot on everybody's practice, but they do give you a sign of what the legislature is thinking about and where they're going. So sensitive services, protection, expansion of scope, yes. Increased penalties for disclosure and not maintaining confidentiality, yes. So there's a lot of that going on in the sensitive services realm. That's probably the hottest area. But this minimum wage and the employee protection in healthcare and just more broadly is happening all over too. But there's just more whistleblower protection statutes in the healthcare area than there are in the normal employment area. So those, anytime there's employee whistleblower protections, it's going to naturally affect healthcare practice as much or more than anybody else.
With that, Keith, I want to thank you. I learned a lot, frankly, and I follow legislature pretty close, but there's a lot of legislation here I hadn't tracked as much or didn't know some of the depth of, so I appreciate it. I hope other participants did. Kathleen, thank you again for putting this together, as always, and Rich and Essentia. He was on for his few, but he took time away from his vacation to join us, and very much appreciate that. To all you participants who were here and are still here, thank you. And we'll look to scheduling something again soon.